Well, hello, everyone. Welcome to WTPN, We the People Network. I'm Doug Malo, and I'm here with my co-host, Ed Dolezal. And we are very excited to have a good friend of ours and patriot, Tom Sikes, back on the podcast today. For those of you who do not
Excuse
know,
me, Doug. Yeah,
yeah, so
I'm glad to be here.
there you go. For those of you who do not know, Tom is a moderator for the Sarasota Assembly. And today we're going to be discussing Florida statutes, including Special Session C regarding surety bonds. Well, welcome back, Tom. It's good to have you.
Okay, yeah. I as we decline and we decline our spirits and get into this thing. I say decline, but because we'll never stop fighting, and every time that we turn around, we find something new that's going on. I think if you remember, and there's been a recent flurry of activity from a lady called Mickey Cron, and she had some claim to fame some years ago or some months ago, a couple of years now, about bonds for the wind. Well, in Florida, we tried to start using this bonds for the wind, and we started going through. In my case here in Sarasota, we put out a request, a Freedom of Information request, then we put out a petition for redress of grievance and requested copies of their oaths and their bonds. And so this was pretty much like pulling hen's teeth because we were using some languages that they obviously didn't know, and that was in the form of bonds and unencumbered property. And so when I started digging into what the actual statutes were, and then I happened to have a meeting and got in touch with one of the auditors for Sarasota County under the Inspector General's office for the county. I asked a simple question. I said, from the way I read the statutes, I'm supposed to be able to ask you and receive a copy of the bond for any of your commissioners. And then I got a response back that, well, since 2008 and the legislature made a discovery that bonds were optional, we chose not to do bonds. And so I said, I need some explanation. So what I found out is that in 1998, the Florida legislature did make some changes, and they made it to one of the very specific statutes that we wanted to talk about, and it's 137. And in 1998, the Florida legislatures made a ruling that um, county commissioners could make it optional for their officers to have a bond. They could decide which officers needed a bond or not.
Well, that's convenient.
Yeah, yeah, that was. And so I started looking at the way the legislature was written. And so to kind of solidify my position, I went to the University of Florida Law School and looked up the procedures for writing legislative law. And it was very clear at that point when you write legislature that you're very specific and that you only include one idea per line item. In other words, you can't mix two laws in one sentence and you've got to do this and this. So it was very specific that you could only include one law per line item. And they also included if additional explanation so that the true intent of the law can be determined from the legislators, additional lines may be put in to further clarify their position. So taking that into consideration, when I went back up and pulled the full 137, it states very specifically that bonds required by the Board of County Commissioners for county officer. And then they made the changes that each Board of County Commissioners may, by ordinance, require any county officer to give a bond. And having been a previous elected official in Virginia as a county commissioner or county supervisor for 12 years, I have had to argue sometimes the meanings of the word that's written in legislatures. And the word may is just what that is. It's an option. So they may require bonds from any of their county officers. But when you get into looking at 137.02, it goes back and says bond for tax collector. Tax collectors must have a bond. 137.03, bond of property appraisers. Property appraisers in the county must have a bond. And then you get to the infamous 137.04. And while I've been on many discussions with the words in our legislature, I have never had a conversation on a word that says must. And 137.04, county commissioners to give bond. Each county commissioner, whether elected or appointed to such office, must give a bond conditioned by the faithful performance of the duties of his or her office as required by the Board of County Commissioners. They have got to have a bond. So my position is when they are required to have a bond, this in fact incorporates another code, and that's 113.071. And that said sureties upon official bonds. The sureties upon the official bonds of all state, county, and municipal officers shall be the residents of and have sufficient visible property unencumbered within the state, not exempt from sale under legal process, to make good their bonds. And the sureties upon the official bonds of all county and municipal officers shall reside within the county where their principals are upon such bonds reside. So what the Florida statutes are telling us is that in 137.04, every commissioner in the state of Florida must have a bond, and it's a surety bond based upon their performance. And 113.071 states if you're required to have a bond, then you're required to post unencumbered property. So that again means property that you own outright, no mortgages, no liens, no other encumbrances on it. It's yours. So you've got to post that. Now, with
May I?
Yeah.
Let me jump in. Just giving a perspective here for people to comprehend this. The reason why this is so important is because the surety company, which is an insurance company, right, does not place into jeopardy any of its assets. When they bond somebody under a surety bond, it's the man or woman who are applying for the bond that are putting their own personal unencumbered assets on the line. That's why this is so important. I yield.
Yes, it is. Exactly right, Ed. And the purpose for that is, again, that is to protect the insurance company, but the ultimate protection here is for we the people. Now, I understood that this was changed in Sarasota in the year 2008, and I was fortunate enough to go back and have the video of that commissioners meeting, and I will have to say it was quite an education for me to look at the fact that staff at that point in 2008 really ill-informed the commissioners, because when the commissioners asked what was the bond for, was it to cover their Blackberries or their laptops? And the advice from staff at that time was, no, we have liability policies to cover all of those other assets that you have. This was an antiquated requirement back in the early ages that nobody is paying attention to. and only about 15% of the municipalities, of the 250 counties and municipalities in Florida, only about 15% of those current seated commissioners in 2008 actually had bonds.
Well, that's
So,
remarkable. Wow, Tom,
Can I add
incredible.
something else? In fact, when the reason why there was probably that change is because, well, two things. One is when you look at the facts, right? A surety bond forces the obligee, right?
yes.
Forces the obligee to behave and to follow the rules. That's why their personal assets are on the line. Their unencumbered assets on the line. And it's no surprise that they've tried to change this in contravention of the statutes.
Yep. Yes.
May I just take a minute? I want to do it in the beginning because I think a lot of people that are watching, Tom, Ed's kind of an expert in this area. I know that you are. A lot of people don't really have any kind of comprehension about what a surety bond really is. And from my limited comprehension of it, it's a written agreement to guarantee compliance, payment, or performance of an act. It's a unique type of insurance because it involves a three-party agreement. And that, I believe, that is between a principal, the party that purchases the bond, right? And then the surety, the insurance company that guarantees that it will be performed if the principal fails. And then the obligee is the party who requires and often receives the benefit of the surety bond. And so I just wanted to clarify that and kind of give a basic understanding of what we're talking about, because a lot of people don't know the difference between a bond and a surety bond. Is there anything that you all would like to add to that? Because again, I have limited comprehension of it, but is that clear enough for everyone, do you think?
It should be. It's basically based upon personal performance. In other words, if you, as a commissioner, you've got a buddy in the development industry that's a contractor, and you pass legislation that gives favorable preference to your buddy, then that's a conflict of interest. And if you have a friend or any type of thing that you do, that is out of bounds constitutionally, that means that you've got a bond to protect we the people against anything that you may do. Now, I think you and Ed both hit on to the point where it's a little bit of, why did they get rid of it? Why did they assume that it was not? It's as pure simple as CYOA. They wanted to cover their own butts, and they didn't want to be able to get their own property. And I take this back to the supervisor of elections from not informing people what the requirements of their office are. And I think the supervisor of elections in this case is as guilty, if not more, than the people that are coming forward to take up these positions as commissioners, because they don't spend their life in government. They don't understand reading regulations. And so the first person they contact is when they go to the supervisor of elections to file the forms to become a qualified candidate. And if you're not being explained what the terms of your position, then I think that's a gross negligence on the supervisor of elections part by not giving people the rules that they need to have to be in compliance and to properly assume the position of a commissioner. So right now we've got commissioners in Sarasota County that are not lawfully seated in their positions because they don't have a surety bond, nor have they posted unencumbered property. So they got two violations.
Yeah, and they're serious violations, right? Very serious. Ed, didn't you do some research on this side of the pond that the irony of this is that not only did we find out that they don't have their bond, but now instead of the bond, they have some kind of a criminal insurance?
Well, Yeah, in Palm Beach
You
County,
can't make it up, Tom. Go ahead, Tom.
well, in Palm Beach County, the commissioners do have surety bonds and oaths of office. What we did find was actually the Board of Education members, right? We're not in compliance with this. They actually secured a crime policy. Crime.
Crime policy.
So I don't, they, but let's go back to the fundamentals.
I just
In
thought it was
Florida,
interesting to bring that up, but go ahead. I found it funny. Go ahead.
in Florida, as in many other states, when you joined the union, you had a guarantee of Republican form of government, right?
Yes.
And therefore, when that changed in 1871 and they went to a corporation, essentially they do whatever they want. It's a rogue operation, however you look at it, in my opinion. So all of these statutes, it's nice to have, but they don't care. They really don't care. They're not going to observe it. They don't respond. And ultimately, it's their behavior or their lack of conformity to what we call common law, where we can hold them responsible. It just adds, in my opinion, a lot of urgency and for the people, men and women in every county, to form their grand juries. How else are you going to hold them accountable? They don't care about these statutes. They don't care. Even though they're on the books, they're obviously not observing them. We're no longer a constitutional republic. We're a corporation, bottom line. So they can do whatever they want, much to our chagrin and so on. But ultimately, it just adds a lot of urgency for us, if we want to see a change for the better, to form the grand juries and the assemblies, right?
Absolutely.
Bottom line.
Absolutely. And so what we're doing right now, our next meeting is this coming week, the 30th. And we're going to, as an assembly, make a determination whether we pursue this through a warranto from the assembly, or if we actually turn it over to the grand jury investigators, since we now have a statewide common law grand jury seated here in Sarasota. We may be able to take that to the grand jury and let them make a decision on whether they want to proceed and go forth with that or not. So by having your assembly and your grand jury in your county, it's the best of both worlds, where you can actually investigate, discover, and then you can turn it over to the grand jury for a formal investigation and a formal proceeding.
Tom, let me ask you a question, something that I comprehended finally. It takes a little while. You have to beat it into my head. But from what Roger, our mentor and advisor, had told us on the last call Wednesday, is that if the facts are so compelling, in essence, it's undeniable evidence, we can skip the grand jury and go straight to a common law court of record.
Yes, you basically can, but for the purposes of training and getting people to understand, that option is available. But I would prefer taking it step by step through all of the processes that are available to us. In other words, letting the assembly do a petition for redress and point out the fallacy. Let them send 3 notices. And then if they still don't get a response, then send a default notice. And then once the assembly has an agency such as the commissioners or a school board, once they have them in default by not responding, then turn that case in its entirety over to your grand jury and let them start working, and let your grand jury investigators present a report to your grand jury and then ask for a vote. And there's 3 possibilities with the grand jury. There's a no bill, which means you don't have enough evidence to make anything prove that they're out of bounds. So we're not going to proceed this. So we'll do a no bill. or they can come forth with a presentment. And a presentment states there's evidence, but there's also the possibility that this evidence is not conclusive, that we're going to ask you, we're going to tell you what the charges are, what the penalties are, and we're going to give you a presentment and 40 days to come back and tell us that we're wrong, that you've got an explanation. You've got, for some reason, if we're saying you were present and committed a crime and you can show that you were in another location and not present, then if you could come up with evidence to prove us different, then we can drop the case and move forward. However, if they don't respond by the start of the 41st day, they are automatically considered guilty of the charges in the presentment, and then it can go directly to a court of record. Now, the last thing that a jury can do is an indictment. And this is when they say, yes, there is absolutely enough evidence, that there is enough proof here that a crime, a trespass has been committed, and that it needs to go to trial. And that's when they do an indictment and seal it. So that's where your grand jury goes. So that's done by the people in the county coming together as an assembly to take the responsibility to govern how your county is operated. And that's going to be a big job for a lot of us, because we now have de facto governments in place in all of our counties. We've got education systems, we've got child protective services, we've got sheriff's offices arresting people in violation of the Fifth Amendment. We've got everything that's going on. So we know that there's an estimate somewhere around close to 80% of the government is a waste. So that when we come...
Sorry, can I ask, I just want to interject something before I forget. In the process of determining whether or not the civil servants have actually posted their personal assets, unencumbered personal assets, for people to be aware of, very recently there was quite a bit of a reaction to the obligation of filing a Form 60, which actually required or enforced that particular point. Have you seen that compliance take place in your county, Tom?
I have not seen such a form, but I can tell you compliance with 113071 and filing unencumbered property does not exist in Sarasota County.
Okay. Thank you.
Okay.
Tom, if I may, where are you in this process? You know, you mentioned the number of people that are not carrying their surety bond in Sarasota. Where are you all in this process at the moment? Are you taking action? If so, what steps are you in now?
That action will be performed. I am presenting this evidence to the assembly this coming week, and I will be able to come back and give you an update as to what their decision is. I know what I would like to do, but we're all an assembly. And so, you know, what I'd like to do with a lot of things, I'd probably end up in jail with for sure. But right now, because every time I see this, you know, in my background, having served as an elected person gives me the right to be a little pissed with these guys right now, because I was just like them. I didn't have a clue of any of this was going on. And 4 years ago, when I started diving into child trafficking, and then when I started finding out one item that led to another, that led to another, it's no reason and no excuse for anybody that's sitting in office today. And I don't give a damn if you're wearing a red hat or a blue hat. You need to be finding out what's true, and you need to be finding out how this government has been swindled and how we, the people, have been enslaved to sponsor this. And if you don't have the gumption if you don't have the energy to go out and do the research yourself. Because 4 years ago, there was very little information. 3 years ago, there was some, but not much. 2 years ago, things are starting. And now this year, there is a flood of information coming across all the alternative information. Still nothing on mainstream media, but we know that's controlled and owned. So there's not a thing out here to prevent these people, but sheer damn laziness to get out and find out what the truth is and find out. You made an oath to your Constitution. You took an oath that you were going to support that. How about the first step? Read the damn thing. How about not reading the Constitution and understanding what it says before you swear an oath to it, and then you go off and do everything else in violation of it?
Yeah.
How can you expect the people not to be pissed at your actions?
Well,
You should not be allowed to be in office. You should not be allowed to be a community member because you haven't taken the effort. You haven't expended the effort to find out the truth, and you're hiding behind these glass doors, and you're expecting that to stop this hailstorm that's coming through.
well, Tom, I like the fact that you mentioned that if it was up to you, you'd probably do something you maybe shouldn't have and ended up in jail. I get the passion. I know what you mean by that.
Yes.
But it's very important that we bring up that point because we make a point on WTPN always to talk about this, because right now there's many voices out there and they're telling people to do things that maybe they shouldn't be doing. We always speak of the common law as a defensive weapon, not as an offensive weapon. And people like yourself and me who have passion, and Ed, and we can something, well, maybe Ed, he's a little more conservative and thinks a lot clearer than I do sometimes. But it's important we have the assembly. We have a vote. We can step back and say, okay, let's really look at common law. Let's see what is the appropriate action. What is the decorum? What are we supposed to do? What are we not supposed to do? What's going to get us in trouble and what will keep us safe? And what is the proper thing to do right now? So I just want to emphasize that point, being that you said that, because there are a lot of people out there right now. They're telling people to do things and they're getting in trouble and they're putting themselves in harm's way. And so we always bring that up on the show. So I just wanted to kind of interject that. And I do appreciate it.
That's absolutely critical. We know now, and from our experience, and our assembly work here in Florida has been going on for several years in different parts of the country. And we have people in jail today because they were following this process and thought they understood what they were doing. And as our knowledge of the existing system expands, what is in place today, one of the most critical rules that we have learned is that it's broke. The existing system is broke. We cannot fix it. It is not a form of government as we understand it. It's strictly a corporation. It's been a corporation since 1871. And when you walk into court today and you start claiming, I've got rights, I've got the Constitution, they're a corporation. They don't give a squat about our constitutional rights because it's not in that jurisdiction. We are in a corporation's board meeting room. We're not in a court of law. So anytime that we try to do any type of an action, we got to make sure that we do it within common law. We do not reach into the de facto court system. We do not reach into the de facto law system because it's the legal system. It's not law. And so we are advising people that we have constitutional rights of our petitions for redress. So my advice to the people is every time you find one of your officials out of bounds, call their hand on it, do a petition for redress, and you send a notice. If they don't do anything, you send another notice, and you send it until you've sent 3 notices and a default notice, was basically you've sent them 4 notices 10 days apart So it's taken you a month and a half to send this out. But at the end of that period, when you've got that default notice in hand, you have collected undeniable evidence that this particular person who is in violation of the Constitution has committed an act that needs to remove them from office. So we're compiling and we're keeping all of this information. We're keeping all of our sealed indictments from the grand jury. We're keeping the documentation and waiting until the hammer drops.
Very good.
And I don't know how much you want to get into the hammer drops, but you know what I'm saying. We do not step into their system. We do not expose ourselves.
Yep.
We do not poke anybody in the eye, but we still do what we can lawfully, and that's submit petition for redress and say, you're out of bounds.
Yep.
And call their hand on it and keep the documentation.
Yeah, I'm sorry, Ed, we emphasize here all the time, restore, not reform, right? Restore, not reform. And I say, don't jump into the water with these people because you're going to end up drowning. And you just don't want to do that. So Ed, I'm sorry, go ahead.
That's okay. No, I just want to make it very clear.
Yep.
Very clear what Tom is talking about. He mentioned jurisdiction. So again, this is very, very important that people become cognizant and internalize the fact that men and women under common law are on the land. When we're dragged into a corporate situation, that's a different jurisdiction under admiralty law, Roman law, commercial law. It has nothing to do with us. They make us believe it does, but it does not. It's only for corporations. So common law is absolutely key. And the other point is everybody has got to take the time to self-educate, follow conference calls, which you will annotate at the bottom of this podcast, so that they become conversant in the correct vocabulary. Very, very key. So it's critical, jurisdiction, vocabulary, which will build confidence and holding your status as a man and woman on the land. I yield.
To add to that point, statutes are not laws for us.
Correct.
The original intent of we the people and our forefathers was to create government, and they create statutes, ordinances, rules, regulations, control the actions of the people that are in government, not we the people that are not government employees. And to further that point, there have been 3 specific cases in our Supreme Court, and it was a Flornay versus First National Bank of Shreveport. There was a Self versus Ray in 1963, and there was a recent case in 1985 by Rodriguez and Donovan, and they all state common law is the real law, supreme law of the land. The codes, rules, regulations, policies, and statutes are not the law for we the people. So there have been 3 Supreme Court cases, and we built this entire nation off of case law. And I happened to present that in a case I was representing a lady neighbor here. And the Justice of the Peace said, well, Mr. Sikes, those Supreme Court cases, those are just opinions. Well, I want to take him to task for that statement as well, because Supreme Court decisions, while they may be decisions, are still part of our case law that's established this country. I yield.
Yeah. Well, jumping in on 2 things. One is there's always U.S. against Williams in 1992 when you had Superior Court Judge Antonin Scalia that said, the grand jury is the will of the people, and then it is, independent of any corporate control or any government. So it just further anchors the fact that common law is superior and supreme.
And with that statement, the decision of a grand jury can never be appealed or challenged because it is the decision of we the people. And when you have a grand jury that votes 50% plus one on any issue, it's a completed, done, and totally completed issue.
Yeah, it supersedes any other jurisdiction, and
yes,
and stands, and that's it. The people speak, and it stands.
Well, yeah, and there's a lot of commissioners in this state that really need to understand that the voice of an assembly is over top of them, that the assembly is the actual governing body of the county, and it reigns superior over any commissions or any of the other appointed departments. Very powerful. People understand that, and you start pushing it.
Well, Tom, we really appreciate you. Last time you were on, for those who don't know, Tom went through what they're doing against the fluoride issue, and that was a well-received message. You can go back and look at that if you've missed it. But we're always so grateful for you to come on and give us an update of what's going on over there in the great city of Sarasota. And we really appreciate all you're doing, and you're kind of a leader, which is really nice, directing the path and showing us the way to go and the proper way to do it without harming people. That's very important to us.
Very important.
And here at WTPN and to the General Jural Assemblies nationwide. So we're very, very grateful to you. Ed or Tom, is there any closing remarks you'd like? Ed seems like he's ready to go because you're getting them all fired up now. But anything you guys would like to add to this, and we'll go forward from there, and we'll definitely have you back on again to get an update, Tom, about what happens with your procedures. But go ahead, Ed. I'm sorry.
Thank you, Tom. I just wanted to actually correct myself. I said Form 60. It's actually Form 6. So it does exist, and it's called Full and Public Disclosure of Financial Interests. That's it. Okay. Thank you.
Tom, is there anything else you'd like to tell us or share with us? Or
yes, for anybody that's listening to this, the decision is yours. We know that this is not about an election. We know that this is an assault, a satanic assault upon mankind, and this is affecting every point of our lives. It's affecting our family, the way we eat, the way we sleep, the way we walk, the way we dream. It's affecting everything. So it's not going to go away. And for you people that are saying, well, I'll just wait until this is over before I see about getting involved. No, get off your butts, find an assembly. If you don't have an assembly, contact Doug, Ed, myself, Roger, Dardell, any one of us. We'll come help you start an assembly in your county, but we need to get Florida into a de jure status, which means back into the control of we the people, and we need 20 counties. We've got one county fully settled, another one in Palm Beach, almost there. So we need to start pushing people to get off of the couch and get involved. Don't get sidetracked by all of these other political parties that are coming up. There's one called the Republican Assembly. There's other groups that are starting up. They're patriot groups. There's all of these different groups. They're not the ones that have the authorization from our forefathers, and they're not the ones that are following General MacArthur's path to restore this country to its freedom. So get involved with an assembly, a general jural assembly in your county, and make it happen, because it's not going to happen if we sit back and keep watching the mainstream media, which is getting us nowhere. Get invited, get pissed, get invited, get up, get moving, and get excited, get moving, and save this country. This is not a spectator sport, folks. It's nothing you can sit on the sidelines and watch podcasts and feel like you're part of it. You've got to get out there and pull on the rope yourself. That's it.
There you have it. I don't know what else to say to that. Other
Well,
than
I just want to add, I want to
yeah.
add one thing very quickly. There's also the children. The children, they are after the children, not just in schools, but much, much worse. So, yes, families, yes, neighborhoods, yes, friends, but ultimately they want to get at our children. So, really, as Tom said, time to get up and get moving. I yield.
Well, thank you guys. We have a customer around here, Tom. I'm just going to close this out with this little bit here. I do often. I always say that we want to remind everyone that we the people is a term that the Constitution derives its power not from the king, certainly not from what we call our president or Congress, but from the people themselves. And this channel is the people's channel. And please contact us, let us know what you'd like to hear and see. Share a link below and follow us. And we just are so grateful to Tom again. I want to thank you so much, and we can't wait to have you back. Appreciate Ed, you as well, and all your time today, Tom. Thank you again. Appreciate you.
Thanks, Tom.
Okay.
Appreciate it. Thanks, Tom.
All right. Thanks, guys.
Take care, buddy. Keep
Yeah,
up.
God bless.
All right.
Okay, man.